Speaker, I have to say that I agree with the Minister of Justice that the Small Claims Court Act is an important part of the judicial system here in Nova Scotia and allows for the quick resolution of disputes. But I have to say, Mr. Speaker, that is far from being the whole story of Small Claims Court. Now, I have some experience in Small Claims Court. I was in there a couple of months ago on behalf of a client on a on behalf of a constituent on a residential tenancies matter. Sorry, Mr. Speaker. On behalf of a constituent on a residential tenancies matter, and I'm glad to say that we were successful. But the reality of the Small Claims Court, Mr. Speaker, is considerably different than one would suspect from the remarks of the former Minister of Justice there, the Minister of Transportation. Small Claims Court really is the Wild West of the Nova Scotia justice system, Mr. Speaker. It allows for quick resolution of claims, but you don't know who the witnesses are going to be, you don't know what they're going to say, you don't know what documents they're going to produce. You're going in blind and hoping things turn out for the best, and you hope that you're prepared for anything that might happen. And Mr. Speaker, if anybody thinks there's no lawyers in Small Claims Court, they're kidding themselves. They are absolutely kidding themselves, because when I was a young lawyer, or should I say a younger lawyer, when I was starting out in law, the limit in small claims the limit in Small Claims Court when I started out in law in the early 90s was $5,000, and there weren't an awful lot of lawyers in Small Claims Court, because for any kind of a serious dispute, your legal fees were going to amount to that much or more, Mr. Speaker. And that is when it was informal and you didn't see a lot of lawyers. But this legislature, over the last 15 years, has bumped up the limit in Small Claims Court to $25,000. $25,000. Now, Mr. Speaker, if you consider that most Canadians, the biggest assets they have are their house and their car, and everything else they have is worth less than $25,000, and for most people their car is worth less than $25,000, just about every asset every Nova Scotian owns is potentially subject to Small Claims Court. $25,000 is a heck of a lot of money, Mr. Speaker, and believe me, there are lawyers in Small Claims Court. And not only that, Mr. Speaker, but what the Small Claims Court has become is something that goes far beyond resolving small disputes between two individuals. You go to Small Claims Court, and the people on the plaintiff's side are, generally speaking, corporations, large corporations, and they'll have a long list of cases that they have on the docket that night, because they can afford to have a lawyer if the lawyer has 2 or 3 or 4 or 5 claims on at the same time. So you have a corporation represented by a big law firm lawyer up against individuals who don't have a lawyer, Mr. Speaker. And not only, so you have people going to court, facing this on the other side, having no idea what the other side is going to say, and generally speaking, having no idea how the law works. That, Mr. Speaker, is the reality of Small Claims Court in Nova Scotia today. And any member of the House who doesn't believe me just has to go down to the Spring Garden Road Courthouse or the Small Claims Court in their local jurisdiction and see what it actually looks like in practice, Mr. Speaker. Now, what the government is proposing to do now, Mr. Speaker, is give the Small Claims Court even more authority, even more jurisdiction than it already has. One of the few things that reins in Small Claims Court and keeps it to some level of groundedness is the fact that it only has the ability to award general damages of $100. And that's been the case for a very long time. So while the upper monetary limit was being pumped up and up and up, the general damages stayed the same. Now, what are general damages, a member might ask, Mr. Speaker? General damages, as opposed to monetary damages, if you can measure something in money, then it's called special damages. If you can't measure something in money, then it's general damages. And the most common examples of general damages are hurt feelings and pain and suffering. There are others, but those are the most common. The kind of things that can't be measured in money, but what the court does is it does try and measure it in money and awards an approximate amount. Now, Mr. Speaker, it's difficult enough in the Wild West of small claims court to confine things to things that can actually be measured by money. For example, if a tenant damages an apartment, the landlord can go to court for the amount it costs to fix up the apartment. Or if a landlord has expended money and the landlord has refused to pay them back, they can go to court, and what happens is the person brings in their invoice or their bill and proves that they spent the money, and the court says, okay, there's your judgment for this amount of money. On top of that, we're now proposing to allow the court to award $2,500, which for most people is a lot of money, for things like pain and suffering or hurt feelings. Now, it's impossible to know how this is going to work out, Mr. Speaker. It could work out well for ordinary litigants, or it could work out very badly. It's impossible to say. General damages are difficult enough for lawyers to deal with because, by definition, they're things that can't be measured in money. So just imagine if you're an unrepresented litigant, somebody's making a claim against you for hurt feelings. How are you supposed to deal with that? You have trouble enough with the evidence and witnesses as it is, and suddenly something's being thrown at you that, by definition, it can't be measured by money. And just to give you an example, Mr. Speaker, of what I mean by the Wild West that is the small claims court, the bill also adds a provision that says an adjudicator is not bound by the rules of evidence applicable to the judicial proceeding. Now, of course, it also says for greater certainty, because that has always been the case. And what I suspect is that there's probably been some appeals to the Supreme Court in which the litigants are complaining that the rules of evidence weren't followed. It has always been the case that the small claims court is not bound by the rules of evidence. But just think about what the implication of that. The rules of evidence are there for a reason. They're not there just for the sake of having rules. You have rules of evidence in order to make sure that the evidence that is brought forward tends to be reliable. That's why you have rules. That's why, for example, in a regular court, hearsay is not allowed, because what somebody told somebody tends not to be reliable. So if you go down to Lower Water Street here to the Nova Scotia Supreme Court, you can't introduce hearsay. But if you go a few, less than a kilometer away to the Spring Garden Road Courthouse, to Small Claims Court, you can do anything. Hearsay? Doesn't matter. Somebody told somebody, who wrote to somebody, who told somebody, that's admissible, Mr. Speaker, because the regular rules of evidence don't apply. So I acknowledge that the bill says for greater certainty, because it recognizes something that has always been the case, but it's an indication to the House of what actually goes on in small claims court. And we're seriously proposing that in this court, we're going to allow them to award general damages that can't be measured in money, of up to $2,500. Mr. Speaker, I'm not sure how this is going to work out. And the other thing is, I've heard that figure before, $2,500. Where have I heard $2,500 before? I remember, Mr. Speaker, that is... Well, yeah, a suggestion has just been made on that side, which is actually wasn't too far from the truth up until yesterday. Up until yesterday, and the members will know why that changed yesterday. Mr. Speaker, $2,500 is the cap imposed by this government on pain and suffering in motor vehicle accidents. That's where I've heard the $2,500 figure before. And I don't think it's a coincidence, Mr. Speaker, that now the small claims court will have jurisdiction over general damages claims of $2,500. What I can't quite work out is what the implications of this are. Now, it may be that this will work out to the benefit of plaintiffs, because up until now, they haven't been able to go to court. Plaintiffs, that is the people who are injured, haven't been able to go to the small claims court for motor vehicle injuries unless they were willing to forego any claim for pain and suffering except for $100. Now they can go to small claims court and collect a full amount. What I think is really going on here, Mr. Speaker, and I don't think it's a coincidence that the figure picked here is $2,500, is that now the motor vehicle insurers can deal with all of their claims quickly and simply, get rid of all the $2,500 capped claims without having to worry about going through the regular court system. I rather suspect that this will ultimately work to the benefit of motor vehicle insurers and not to the benefit of plaintiffs. Because, Mr. Speaker, I can't think of all the numbers that they could have picked for the limit on general damages. I can't think of any other reason why the number this government would have plucked out of the air was $2,500. I would be less suspicious if it was $500, $1,000, $2,000, $5,000, but it happens to match precisely the cap on general damages imposed by this government on people injured in motor vehicle accidents in Nova Scotia. So, Mr. Speaker, those are my thoughts on the Small Claims Court Act. It doesn't work quite the way the former Minister of Justice would have us believe. We all have to have a deep think, Mr. Speaker, about what's going on in the Small Claims Court. It is not working the way the government would like to believe that it is, and this legislature is being asked one more time to increase the jurisdiction of that court. And as I've said on previous occasions, Mr. Speaker, and I'll say again today, I'm not the least bit convinced that that's a good idea. Thank you, Mr. Speaker.
Member for Richmond.
Thank you, Mr. Speaker. As the Justice Critic for the Liberal Caucus, I'm pleased to rise and make a few comments on Bill number 15, amendments to the Small Claims Court Act. Mr. Speaker, over the last couple of sessions, I've had the opportunity to speak on the Small Claims Court on a number of occasions because of some of the changes that have taken place. This government, as has been mentioned, has changed the upper limit on awards in small claims and its jurisdiction on at least two occasions, first moving it up to $10,000 and then moving it up to $25,000. Mr. Speaker, when that change was made, I called upon the then Minister of Justice to commit to undertaking a review after a year of the changes having been implemented to ask the adjudicators, the people who are there hearing these cases, who, Mr. Speaker, in small claims court are lawyers. They're members of the Nova Scotia Bar. They are not judges, but they are there as lawyers and they are called adjudicators. These are the people who have to make decisions that just a number of years ago had a limit of $5,000, which now has a limit of $25,000. And my question to the minister was, would he commit to undertake a review after a year and ask these adjudicators, is $25,000 the right limit? Is it too high? Can we go higher? How is this working? And unfortunately, from the information I've been given, no such review has taken place. So after such a significant change, with no review being done, we're now being presented with further changes to the Small Claims Court Act. Again, not to have been given any indication whether this is something that the adjudicators have given their support for, whether Nova Scotia Bar Society has been involved in the discussions on these changes. We have not been given any indication of that. Mr. Speaker, the member from Halifax Fairview in his comments spoke about having been at Small Claims Court. And I've not been at Small Claims here in Halifax, but I can tell you I've attended Small Claims Court at the Erishat Courthouse, the historic Erishat Courthouse, I might add, Mr. Speaker, on a number of occasions, both with constituents and with clients. And it's a very interesting procedure, to say the least, and it was meant, when it was first created, to be able to settle disputes outside of having lawyers present, relatively minor disputes that did not meet the test of being in provincial court, and was certainly a means of removing some of the strain from the provincial court system. But, Mr. Speaker, as we continue to increase the awards in small claims, these are no longer minor disputes. $25,000 is a lot of money. I can tell you, Mr. Speaker, $25,000 is more than the average income of many households in the riding I represent. So that was my concern when the government first made that change of bringing it up as high as $25,000, and unfortunately we have no information, no statistics, and no review has been done to indicate to us as the elected members of this House whether that change has been positive, negative, or whether the court is working as well as it should. Mr. Speaker, there are two significant changes that are being proposed here in this bill. And I know that the member from Halifax Fairview did touch on some of those changes. Let me talk about the change, which I don't believe he touched on too much, but what was explained to us, Mr. Speaker, is that right now in your traditional court system, if you're going to come in with an expert report, let's say it's a medical report that comes from a specialist, and you're going to present that as evidence. In our traditional court system, you need to make that doctor available who wrote the report so that they can be cross-examined by the other party. If you don't do that, the report is inadmissible because of the fact it doesn't allow the other party to be able to ask questions to the author of the report. What is being suggested in these changes is that in small claims court, you would be allowed to enter the report of an expert and not make that expert available for cross-examination. Mr. Speaker, that's a significant departure from our traditional justice system here in the province. And the way it was explained to me was that it would be up to the adjudicator to determine, upon receiving this expert report, just how much weight they were going to give the report without the author being made available for cross-examination. Mr. Speaker, I'm not sure why that change is being put in and why we are diverting away from our normal justice principles in our existing court system. My fear is that now that we've moved to $25,000, lawyers who may be showing up there against an unrepresented party are going to come forward with expert reports knowing that the other party probably does not have the means to provide similar reports, and yet it's going to be able to introduce them without ever making the author available for cross-examination. Again, I'm at a bit of a loss to understand the justification of making this move for small claims court, where it would apply there, but it doesn't apply in the rest of our court system. So I do look forward to the presentations we may or may not receive from law amendments. And again, these are the types of changes, Mr. Speaker, that I'm at a loss to understand why the government, in bringing them forward, would not have done some form of consultation with the Nova Scotia Bar Society, for example, which is the body that represents lawyers throughout our province. If they were coming forward with these changes to say we have the stamp of approval from the Bar Society and they agree that these are changes that are going to strengthen our small claims court, I would have much more confidence in this legislation than being asked on my own to determine, is this going to be a positive move for the small claims court? I look forward to further debate on that specific amendment to allow expert reports without having the author of the report present for cross-examination. But the member from Halifax Fairview spoke as well about moving general damages from $100 to $2,500. And I know that he's indicated he has suspicions of that figure. Let me help him in saying he should be suspicious no longer. During the briefing that his justice critic would have attended with me, it was made clear that the $2,500 was put there because it is to match the cap on general damages made available for motor vehicle accidents here in this province. So there's no need to be suspicious. It's a reality. It's the government's intention to see those cases move from provincial court into our small claims court. What is going to be the results of that, Mr. Speaker? That's what's unclear. And that's, again, where we're being asked on our own to determine, is this going to be a good move for small claims court? We have no indication from the Nova Scotia Bar Society whether they feel this is going to be a positive move, because when you talk to the Bar Society about this, Mr. Speaker, you're going to have lawyers who both represent insurance companies that will tell you what their feelings are, and you have lawyers who represent plaintiffs and injured parties that will tell you if they believe this is going to be a good decision or not, because these are the people who deal with these cases on a daily basis. We don't. I know I don't, and I don't think the member from Halifax Fairview does. And it would be nice if we would have the Bar Society and these experts, in essence, be able to tell us whether this is going to be a positive move or a negative move. And Mr. Speaker, when such legislation comes forward and we have no idea who is pushing for this, is this the Department of Justice? Is this something the adjudicators of the small claims court have indicated that they support? Is this something the Bar Society has given its endorsement to? We have absolutely no idea. We're left to wonder. And Mr. Speaker, I have to remind the government as well, and remind the former Minister of Justice, that last session he brought forward a piece of legislation which would have abandoned the family court and would have merged it back with the Supreme Court. Mr. Speaker, at that time, I asked the same question. Who is pushing for this change? Is it the Bar Society? Is it the Supreme Court? Is it the Family Court? Who is it? And Mr. Speaker, lo and behold, when further discussions took place, it was unclear who had been pushing for this change, and the government, in its wisdom, withdrew the legislation immediately. And I note that it has not been brought forward in this session. So, Mr. Speaker, that concerns me. How did a bill which would have significantly changed our court system in this province, and we're still trying to figure out who was pushing for the change to start off with? That's not the way our legislature is supposed to work, and I'd submit to you it's not the way government is supposed to work. If we're bringing forward these changes, the government has a responsibility to clearly tell the members of this House who is pushing for the change, why is the change going to be positive, and what affected organizations are giving their support for the change. That is not being done. It wasn't done in that bill that was withdrawn, and it apparently doesn't seem to be the approach being used for these changes to the Small Claims Court Act. So, Mr. Speaker, I remain concerned about these changes. I expressed my concerns and my reservations when the cap was moved up to $25,000, and I remain concerned about these changes to suddenly increase general damages from $100 to $2,500, to all of a sudden invite insurance claims into small claims court where they have never been, and now as well to change the rules of evidence in the small claims court to suddenly allow expert reports when the authors do not have to be present for cross-examination. Mr. Speaker, I would be more comfortable with these changes if we were to get an assurance from the Minister of Justice that a review will take place 1 year from the time that these changes have been implemented, and that review would be brought back to this House for consideration by the members to fully understand the impact of the changes and whether they have been positive or negative, or whether there is further review that needs to take place as a result. So with that, Mr. Speaker, I do hope the Minister of Justice will take into consideration the concerns I've raised, the request that I've made to commit to that type of a review, and we will await to see what discussions are going to take place at law amendments on this piece of legislation, and we'll make our determinations on how we move forward from there, but we'll certainly be supporting it moving on second reading to law amendments. Thank you, Mr. Speaker.
Thank you. The Chair will recognize the Acting Minister of Justice to close debate on number 15, Small Claims Court, the Honourable the Minister of Transportation, Infrastructure, Renewal.
Thank you, Mr. Speaker. I'd like to thank the members opposite for their comments, and I am sure the Minister of Justice will take into consideration your comments and suggestions. With that, I'll move second reading of Bill number 15.
Thank you. The question has been called. Is the House ready for the question? All those in favour of the motion, please say aye. Against? Motion carried.
Bill 15, entitled An Act to Amend Chapter 430 of the Revised Statutes 1989, Small Claims Court Act.
Order that this bill be referred to Committee on Law Amendments. The Honourable Deputy Government House Leader.
Thank you, Mr. Speaker. Would you please call Bill number 19, Class Proceedings Act?
Bill number 19, the Class Proceedings Act. The Honourable the Acting Minister of Justice.
Thank you, Mr. Speaker. And again, on behalf of the Minister of Justice, I'm pleased to rise today on the second reading of Bill number 19, the Class Proceedings Act. In recent years, Mr. Speaker, class proceedings have become a much more common phenomenon both in Canada and the United States. This legislation, Mr. Speaker, will formally allow class action lawsuits to be filed in Nova Scotia. I want to be clear, Mr. Speaker, that Nova Scotians have always had the ability to launch and participate in class action lawsuits. Indeed, the Supreme Court of Canada, Mr. Speaker, confirmed years ago that even in the absence of legislation, courts had the jurisdiction to enable class proceedings to be brought forward. This legislation, however, responds to requests from the legal community to clarify the rules surrounding class action lawsuits in Nova Scotia. I believe, Mr. Speaker, that this legislation will also make it easier and more cost-effective for plaintiffs to bring such proceedings forward. Mr. Speaker, this legislation addresses such matters as the process of certifying a class proceeding, the court's powers to establish classes and subclasses, and to appoint representative parties, the ability of class members to opt out of a proceeding, and the conduct of class proceedings, and the court's power to make powers necessary to ensure the fair and expeditious determination of common issues, the content of orders and the making of aggregate monetary awards, and the emission of statistical evidence. As I mentioned earlier, Mr. Speaker, the Nova Scotia Barrister Society has expressed their support for this legislation. The Barrister Society of Nova Scotia, as has the Nova Scotia Judiciary. In fact, Mr. Speaker, most provinces in Canada already have class action proceedings legislation, and this legislation is modeled on what already exists in other provinces. Mr. Speaker, this legislation establishes more effective court process and will enhance the administration of justice in Nova Scotia. I look forward to the support of the other parties with relation to this bill, and on that, Mr. Speaker, I move second reading of Bill number 19.
Thank you. The honourable member for Halifax Fairview.
Thank you, Mr. Speaker. You know, Mr. Speaker, this is a good bill that has the potential to make life better for Nova Scotians, which, even though it's highly technical, this could be one of the most significant things that this House does in this sitting that will have a real impact on real people across the province. And I'll explain briefly why, Mr. Speaker. When I was a younger lawyer, there were no class proceedings in Nova Scotia. And although the term class action suit gets thrown around a lot, Mr. Speaker, in fact, in Nova Scotia, we did not have the ability to file class action lawsuits. The acting Minister of Justice is quite correct that a few years ago, it wasn't a long time ago, but a few years ago, the Supreme Court of Canada decided that there was something called a common law class action suit. And so in Nova Scotia, we've had class action suits now, but it's never been exactly clear exactly what the rules were. Because it hadn't been legislated, the courts were kind of making up the rules as they went along, or making it up is the wrong word, but they were shaping the rules as cases unfolded. And so the great benefit of this bill, of course, Mr. Speaker, is it makes it statutory and makes clear to everybody exactly what the rules are. Now, class action lawsuits are a powerful tool for ordinary people, Mr. Speaker, because the whole essence of them is that each individual in the class doesn't have enough of a financial interest to carry the lawsuit on their own. For example, the class action lawsuits have been used quite widely in the United States for consumer protection. And one of the reasons why American consumers are so well protected is because of the widespread use of class action lawsuits there, where, for example, if somebody invests perhaps $15 in a piece of software that not only doesn't work but maybe damages their computer, you might have 1 million people with a $15 loss. And of course, it's not worth taking even to a small claims court, but when you put everybody together in a class, suddenly you have a case that's worth taking forward. And so in the consumer protection area, that's where I expect to see the main benefit for Nova Scotians, is that now it's going to be a lot easier for them to complain about when things go wrong with products and services that they've been sold. Now, I have to say, Mr. Speaker, that the other group that is most often on the receiving end of a class action lawsuit is governments. Because when their citizens have a complaint that individually is not worth a lot of money, but collectively is worth a lot of money, a class action lawsuit is very powerful. So our government is in the position here, Mr. Speaker, where they want to pass a good bill to set the rules for class action lawsuits, but at the same time, within the Department of Justice, they know that they're going to be on the receiving end of a lot of these class action lawsuits. So they kind of have an interest in making it difficult for people to actually file a suit, so that the right to file a class action lawsuit is more theoretical than real. And indeed, Mr. Speaker, after consulting with some of the lawyers around town who actually do this stuff, it turns out that there is an important difference between this bill and the uniform legislation in Canada. There is a body called the Uniform Law Conference who do a lot of good work, and what they do is they develop a model bill, and they look at all the issues, they do a lot of research, they do great work, and then they recommend to the provinces that, this is a good model if you're all going to pass the same kind of legislation. Now, if there's going to be a difference between the uniform bill and what the government is proposing, then, Mr. Speaker, I think it's incumbent on the government to explain why they've made that choice. And it has been pointed out to me by one of the lawyers in town who actually does class action lawsuits and can be expected to take more in future, that there is one piece of advice that the lawyers have given to the government that the government has not taken. And that has to do with the criteria that have to be met in order for a class action lawsuit to be certified. And it has to do, Mr. Speaker, whether the class action suit can deal with the whole issue or only sometimes parts of it. Clearly, it's better for the plaintiffs if you can use a class action to resolve not only the whole lawsuit, but sometimes parts of it. For example, there's different pieces to a lawsuit. There's causation of damages, there's responsibility for damages, there's the amount of damages. And it has been pointed out to me that there's a very significant difference in this bill from the uniform bill, which would make it harder to certify a class action lawsuit. And those same lawyers have told me that they have registered with the Office of Legislative Counsel to appear before law amendments. So I do look forward to them having the opportunity to explain to all of us what the significance of these differences are. Because if this bill passes in such a way that makes it actually too difficult to file a class action lawsuit, then the bill won't be worth the paper it's written on, and Nova Scotia citizens won't get the benefit that they should get from this bill. And Mr. Speaker, Nova Scotians have always had the opportunity to participate in class actions. It's just that they've had to sign on to class actions launched in other jurisdictions. When I was a younger lawyer, I actually got involved in one of these class action lawsuits. When I was the lawyer for the Workers' Compensation Board, we signed on to a class action lawsuit in the United States dealing with asbestos, because many, many Nova Scotians were injured on the job by working with and breathing in asbestos. And there are some dreadful diseases caused by asbestos, the worst one being mesothelioma. But there are many others as well, Mr. Speaker. Many Nova Scotians died or were very badly injured because they had to work around asbestos. And the best way that we could get money to those workers and their families was to sign on to that American lawsuit, which had been going on for a number of years. And I'm pleased to say, Mr. Speaker, that as a lawyer for the Workers' Compensation Board, I was able to bring into this province several million dollars, which was distributed to injured Nova Scotians and their families. And the reason we were able to do that is because of a well-functioning class action system in the United States. So what I earnestly hope is that here in Nova Scotia, we too will have a well-functioning class action system, because it is a good way to get compensation for people who have been injured by defective products, injured by dangerous products, consumers who've been ripped off, frankly, Mr. Speaker, and it is also a mechanism by which citizens can hold their government accountable. And as the bill moves through the stages, Mr. Speaker, particularly law amendments, I think we need to explore the idea of why this government has departed from the uniform bill, which is recommended to all provinces, and has departed from it in a way that will make it more difficult for Nova Scotians to file class action lawsuits, and indeed will make it more difficult for citizens to hold their government accountable. Thank you, Mr. Speaker.
Thank you. The honourable member for Richmond.
Well, Mr. Speaker, it's a pleasure to rise on Bill number 19, a act to review the Class Proceedings Act, to establish Class Proceedings Act, I should say. And Mr. Speaker, how refreshing it was to hear a minister introduce a justice bill and use the words bar society, judiciary, all these organizations that deal with the justice system in this province actually having been signing off on this piece of legislation. And I commend the Minister of Transportation and Infrastructure Renewal. I believe he may have repeated himself on a few occasions to emphasize the point which he says just for me, but it's not just for me, it's for all Nova Scotians, Mr. Speaker, for the people to know that the bill is coming forward not just as a Conservative bill, not just as a government bill, but one which clearly has had the consultation and has had the discussions and obviously has been given the endorsement to be brought forward here to this legislature. And Mr. Speaker, I would have had much greater confidence in the other justice bills which were brought forward had the minister introducing them been able to give the same type of introduction as what was given for this specific piece of legislation. And I would hope, Mr. Speaker, in my comments to encourage the Minister of Justice and for his colleagues to give the message clearly to the Minister of Justice that in the future the responsible approach would be to bring legislation forward which has clearly been vetted through the Bar Society, through the judiciary, and is being endorsed when it is tabled here in the House. I don't think it was too difficult to do, and it didn't seem to cause the minister any discomfort in saying it, so I do hope that is something that we will get again in the future. Mr. Speaker, as has been said, our civil procedure rules did allow for class action lawsuits in our province, but the rules of procedure were not clear as to how to get a class action started, what the parameters around that were, and our understanding from when the Minister of Justice did provide his bill briefing was that we are the only province left in Canada that did not have specific rules for class proceeding. So obviously, Mr. Speaker, this is an important step for our province. You have had some of the discussions that's taken place. The member from Halifax Fairview, for example, has indicated that class action lawsuits are not a new concept. They may be relatively new to us here in Nova Scotia, but we're certainly well aware of some of the class action lawsuits which have taken place in the United States. And as has been mentioned, it has gone a long ways to provide consumer protection. And it has clearly sent the message to companies and to providers that if they are going to have a defective product or a defective service, there's going to be a price to pay. And as has been mentioned, what class action lawsuits allow is that rather than expecting that one individual can bear the legal costs of bringing a proceeding forward, by grouping everyone together, it allows them to share the costs, and while at the same time being able to bring forward a much stronger case when pursuing an action against another individual or company. And as has been mentioned, it is as well helped to settle suits with the government and to hold government accountable for both current decisions and even decisions which have been made in the past. Mr. Speaker, one of the interesting points in the legislation as we reviewed what was being proposed is that advertising and notice of a class action lawsuit, while in the past would have been done traditionally through paper ads, letters, etc., we note that this legislation will also allow it to take place as a form of advertising by creating and maintaining an internet site indicating a class action lawsuit is being pursued. So obviously I think we're moving ahead in light of the technology that exists today and allowing this new medium to be a means of posting class action lawsuits as well. So again, Mr. Speaker, I do look forward to law amendments. It has been suggested by the member from Halifax Fairview that there may be some presentations suggesting some changes that might take place. And may I as well say, I do hope for the sake of my colleague from Halifax Fairview that the justice critic from Timberley Prospect may be sharing part of his salary with the member from Halifax Fairview in light of the work that he has undertaken today on behalf of the justice critic, but certainly I hope he'll take that under consideration. But Mr. Speaker, with that, I again look forward to this bill moving to a second reading, and I again hope that the Minister of Transportation and Infrastructure Renewal will give the message loud and clear to the Justice Minister of the pleasure of the Liberal Justice critic at hearing the support and the endorsement that was given to this bill prior to it being tabled here in the House today. Thank you, Mr. Speaker.
Thank you. I'll recognize the Acting Minister of Justice to close debate on Class Proceedings Act. The Honourable the Minister of Transportation and Infrastructure Renewal.
Thank you, Mr. Speaker. And again, I'd like to thank the critics opposite for their consideration and the issues they have around this bill and for their cooperation. And with that, Mr. Speaker, I move second reading of Bill number 19.
Thank you. Is the House ready for the question? All those in favour of the motion, please say aye. Aye. Against? Motion carried.
Bill 19, entitled An Act Respecting Class Proceedings.
Order that this bill be referred to the Committee on Law Amendments. The Deputy Government House Leader.
Thank you, Mr. Speaker. That concludes the government's business for today. I move we now do rise to meet again on Monday at 7 p.m. till 10 p.m. where after the daily routine, the government business will be public bills for second reading.
Thank you. The motion for adjournment has been made. All those in favor of the motion, please say aye. Against? Motion carried. The House will rise to sit again on Monday at 7 p.m. The House stands adjourned.